Florida lawmakers have already filed a wave of proposed bills for the 2026 legislative session, and many could significantly reshape how firearms and ammunition are purchased, carried, and stored in the state of Florida. From background checks for bullets to mandatory storage laws in private vehicles, these bills are already stirring debate among gun right advocates and public safety proponents alike. In this video, we'll break down the most important ones so you can stay informed, get involved, and protect your rights. Hello, and welcome to the Firearm Firm channel. I'm attorney James Phillips, a former prosecutor, founding partner of Katz & Phillips PA, and co-author of Florida Gun Law, Armed and Educated. Florida's legislative session is set to kick off in January, and as usual, there seems to be more anti than pro 2A bills. So today, I want to go over what has already been filed so you know what we're facing this upcoming session. Let's start with House Bill 17 and Senate Bill 156, referred to as the Officer Jason Rayner Act, which increases penalties for certain crimes against law enforcement officers. These bills would raise the consequences for offenses like manslaughter, battery, or assault when committed against officers. They also revise the legal standard for using force when resisting an arrest. These bills would add additional language to Florida Statute 776.51 to define good faith for officers making an arrest or detention. Under the bill's proposed language, acting in good faith means to make a sincere and reasonable effort to comply with legal requirements, even if the arrest, detention, or other act is later found to have been unlawful. Supporters say this better protects officers in the line of duty, whereas critics argue it could reduce legal protection in cases of self-defense, especially if the arrest is later found to be unlawful or excessive. Next, we have House Bill 41 and Senate Bill 88, also known as Jamie's Laws. This proposed legislation would require background checks for every sale or transfer of ammunition, not just firearms. Supporters argue that it could help prevent gun violence by keeping ammunition out of the wrong hands, but as we all know, background checks do not keep criminals from getting guns, nor will it keep them from getting ammunition. All this bill would do if it became law is place unnecessary burden on legal purchasers and add a new layer of regulation. To complement these efforts, House Bill 43 and Senate Bill 90 was introduced and filed, and they seek to create a public records exemption for information about individuals who buy or transfer ammunition. While these bills aim to protect privacy, they also suggest that the state would begin collecting and storing that data in the first place, raising new concerns about government surveillance and, most importantly, concerns about potential registries. On the other side of the ledger, we have Senate Bill 52 and Senate Bill 95, which would allow places of worship to use armed volunteers for security without those individuals needing to obtain state security licenses. The ideal is to enable churches and religious institutions to defend themselves amid growing concerns of safety. While supporters see this as a win for community defense and religious freedom, others are wary of the lack of oversight or training requirements for armed volunteers. Several bills focus on how firearms are to be stored in the state of Florida. The first is Senate Bill 80, which would require all gun owners to store firearms and ammunition inside locked compartments when left in a vehicle or vessel. These include glove boxes, trunks, or inside a locked containers securely affixed to the motor vehicle or vessel. Violation of this would be a second-degree misdemeanor and punishable up to 60 days in the county jail. Another storage type bill is House Bill 159 and its companion bill, Senate Bill 256. These bills would make it unlawful for a person not to store a handgun, whether loaded or unloaded, in an unoccupied, unsecured private conveyance or vessel, unless the handgun is kept from ordinary observation in view and secured with a device or mechanism that is securely affixed to the private conveyance or vessel, or kept locked within a trunk, utility, or glove box, or other locked container. Closely related, we have Senate Bill 180, which expands the standard for what counts as criminal negligence when storing a firearm around minors or vulnerable individuals. This bill would make it so that everyone is required to store all loaded firearms in either a securely locked box or container, or in a secure location, or securely locked with a firearm locking mechanism, and would no longer allow for the storage of a loaded firearm in a location which a reasonable person would believe to be secured, or secured with a trigger lock as the statute currently allows for. If passed, this bill would make it easier for the state to charge gun owners, even if no harm occurred, simply for what could be considered unsafe storage under the revised definition. Meanwhile, we have House Bill 133, which would do the opposite of most of the bills on the list by lowering the minimum age to legally purchase a firearm in Florida from 21 back to 18. Supporters say this restores the Second Amendment rights of young adults who can otherwise vote, join the military, or live independently, and I 100% agree. House Bill 155 targets the city of Gainesville specifically, proposing a gun violence prevention pilot program for those ages 10 to 20 who meet certain eligibility requirements laid out in the bill. The bill specifically reads, "The legislature finds that persons under 21 years of age in this state are disproportionately affected by gun violence, which has significant adverse effects on the health, safety, and well-being of persons under 21 years of age. Further, the legislature finds that mental health challenges and unresolved conflicts are contributing factors to the prevalence of gun violence, and that there is a need for targeted mental health and conflict resolution education programs to assist persons under 21 years of age in mitigating these issues. It is the intent of the legislature to establish programs that provide mental health services tailored to the needs of persons under 21 years of age, implement conflict resolution training in schools and community centers to prevent violence, and fund community-based initiatives that address the root causes of gun violence among persons under 21 years of age." Now, personally, I find this bill to be a little suspect, especially since it is only for the city of Gainesville and not for the entire state. I believe this bill is just a stepping stone, and if it gets past this session, well, we can expect to see a bill next session that would expand it to the entire state. I also believe this is a very strategic bill with an underlying objective, and I think everyone should be very cautious of it. Finally, House Bill 171 would declare June as Responsible Firearms Safety Awareness Month in the state of Florida. While this bill is symbolic, I can't help but think it's possibly laying the groundwork for future mandates or programs. Together, all these proposed bills represent a major policy push in Florida's 2026 legislative session. Some seek to enhance penalties and regulate access, while others create new obligations for storage or background checks. Be sure to let us know what you think about these bills down in the comments sections, where you can also leave any questions you may have. Now is the time to contact your representatives, follow these bills, and make sure your voice is heard. The Second Amendment does not defend itself. That's up to us. Until next time, stay armed and educated.